Hello, today's topic is insanity as it refers to criminal justice. By definition, insanity means the state of being seriously mentally ill or being extremely mad, as in crazy, or whatever term you want to call it. So, insanity was the term insanity was popular in the early 1990s and then also in the 1980s. In the term of defense, it was called diminished mental capacity. It was something that could be charged in cases of extreme violence. Some cases were sexual offenses, rape, indecent liberties with a minor, and many others. Pleading insanity was for people who had mental disabilities or illnesses, and this was supposed to prevent them from knowing their actions were wrong. And this is in North Carolina. So, if someone is found not guilty by reason of insanity, this means that they are not allowed. This does not mean they are allowed to go free. An individual that is committed and found to be legally insane by a court must stay in a mental facility until they can prove they are no longer mentally insane or have the illness in question. By being mentally insane, it means they no longer are a danger to others. The amount of time that they are committed to a mental hospital depends on the nature of the crime. If it is serious, like extremely serious, they will be committed for longer. If not, then it will be shorter. An example is someone has been accused of DWI and caused bodily harm. The defense attorneys advise against invoking insanity even though the person is mentally ill. That person may be able to settle for a guilty plea, which will give them a lesser charge, which means a shorter amount of prison time. If they do not plead guilty, then it's a longer sentence, which means they're in jail or prison or mental hospital for a longer period of time. And usually, to establish a mental illness as being cured or no longer around, this usually takes a long time. This also means that the person in question of supposedly having insanity or a mental illness is no longer a threat to others. A person by the name John Hinckley attempted to assassinate President Ronald Reagan and was successful, using the insanity defense to avoid prison, although many states reformed their laws to make this defense much harder to invoke. Sorry about the random scratching, it was an itch. Many states shifted the burden of proof from the prosecutor to the defense, which required attorneys to show clear, convincing evidence of that the defendant was insane. However, if you're mentally ill or disabled, this does not necessarily mean insane, like that the person is insane in the eyes of the law. There can be numerous mental illnesses or disability diagnoses, but not all rise to the level of legal insanity. Examples would be suffering from ADHD or PTSD. These would not be considered as being mentally insane as seen by the court. However, this would be similar to being intoxicated, and the state's mental incapacity may affect one's legal ability to form criminal intent, which means the person knows that they are going to kill someone or commit robbery or something like that. However, being mentally disabled does not automatically result in an acquittal of criminal charges. Many mentally disabled people know the wrongdoings of what they did. So, this would not be something they could use in the court of law to say they were mentally insane because they knew what they were doing, so therefore they were not insane by the court of law. Mental incapacity can sometimes mitigate punishment. This takes a special combination of circumstances in addition to the skill of a top criminal defense attorney, and the National Institute of Mental Health found that less than 1% of county court cases involved the insanity defense, and of those, only 1 in 4 were successful. This seems like a very low rate of successful insanity defenses in the court of law. So, in conclusion, insanity is when someone is not able to know that the crime they committed is illegal and has serious consequences. Most people can use the defense of insanity, but not all of these defenses will succeed in the court of law. It depends on the level of insanity and what the crime was, and by a medical professional, the person has to be declared mentally insane and has to be cleared of being mentally insane or a danger to others by mental hospital staff. So, that is all I have for today. Thank you for listening and have a great day. Goodbye.